And we should be live.
Thank you, Ryan. I did get a message that the meeting was being live streamed. Thanks, everyone. So I'm Teresa Torreseda, and I am first vice chair of the West Virginia Democratic Party. And today I'm chair of this meeting, this hearing of the Board of Appeals. And I just want to start. Thank you, everyone, for holding your good mornings and your greetings. If we could go through individual with a roll call and state your name, and then we'll move through after that. I want to say very quickly too, you will be muted until it's your turn to speak. So I guess roll call will be me calling you out. First of all, I'll issue, I guess, the call to order under our normal rules of procedure. And with regard to roll call, it's very random because I made notes from my screen. So it depends on, I think, how folks joined. But I'll start with Ryan Frankenberry. Ryan, you're currently muted.
Thank you for that. And I think as a good Zoom etiquette, just a reminder that it's good to mute yourself when you're not speaking, but to bring yourself on. So I'm present.
And also we will be, only the participants speaking at the time will be unmuted. So if you are speaking and we can't hear you, we'll speak up and let you start again as we all continue, I think, to work through technology of doing things by Zoom. Ryan, thank you. I have Selena Vickers.
Present.
I have Susan Miley, who is a member of the Board of Appeals.
Present.
And I should have said in this capacity, Ms. Vickers, Mr. Frankenberry are both, I guess we might technically say parties. Lawyers are always too formal. I apologize. I have Kelly Elkins.
Here.
Thanks, Kelly. Good morning. And I have David Thompson.
I'm here.
And I should have said Ms. Elkins, Mr. Thompson, both members of the Board of Appeals. And I have Mike Pushkin, who is chair of the Democratic Party, and here in his role, I think, as a party member named Michael.
Here.
Excellent. Did I miss anyone? I did miss one person, Mr. Sturm, Seth Sturm. Good morning. Mr. Sturm, I don't believe we've met in person, but I see at least your picture on my screen. Good morning.
Good morning. Thank you. Present. Yes.
Very good. And that's all I have. If I missed anybody, let's just start with that. Very good. I think we have everyone then. So we are here today on what is, I guess, being shorthand called the Sturm Grievance, or the Seth Sturm Grievance. And there are two issues just procedurally, which is my role, so bear with me if y'all will, that I think we have to address and take up. And this is to just give everyone an overview of the agenda as I see it. First of all, we are in a public meeting and it is being recorded, and we are required by the rules and bylaws, as I see it, to have a public debate on any rulings of any kind by the Board of Appeals, small or large. So I know first off, and I'm going to give you the overview and then I'm going to back up and go through these things. First off, I've seen what I think was ordered, titled a motion to recuse board member Susan Miley. Second was a motion to dismiss, which was presented in writing last night, but I would note could also be presented orally at this hearing and considered. And then third would be moving to the taking of any evidence in the grievance of the underlying matter. If the Board of Appeals, based on your rulings, which you will find here today after public deliberation, or you will continue after public deliberation, we would move the evidence in that order. So I base that order on the way, frankly, we do things in court or as an attorney, also, and just logic, and also a little bit of the rules of order mixed in. So with that said, I will start with, and everybody will get sort of what I think too is their opportunity to speak on the motion to dismiss, which will come before the presentation of any evidence in order. So I want to start with what has been titled a motion to recuse, filed by Seth Sturm against or on behalf of I should say, asking or requesting board member Susan Miley to recuse herself. And by my read, there is no mechanism for the board to consider this motion. So that said, I do think there's a mechanism for individual members to consider it. But before I move to that, I want to raise that issue and open it for discussion among the board members, should they want it, in terms of my perceived ruling, I guess, or what I'm telling you in advance I see, which is the motion itself is out of order. The reason I believe the motion itself is out of order is because the board can't recuse Ms. Miley. She could consider recusing herself, which I think the board could allow her to do. And I think she should do that and state on the record her consideration. But first, I want to start with any discussion regarding the position regarding the motion to recuse. I would start with board member Mr. Thompson. And it's okay if you say, if I call on you and you say no discussion, I'm trying to make sure we're not muting and therefore silencing anyone who has something to say. You can also wave your hand at me and I'll try to watch. Mr. Thompson.
Can the grievant make a short statement with reference to, or could you perhaps summarize the reason for the motion to recuse Ms. Miley?
Indeed. And so I don't mind doing that at all. In fact, I think it's better left to the grievant. I'll let him speak for himself. What I would ask is, if you'll let me just think about that for a second, I would ask that each side limit themselves to this issue and to this motion. And then we are going to move to the motion to dismiss. And then based on however the Board of Appeals rules move to the evidence, I think it'll proceed more orderly if we do it in that order. And we will come back to folks, in other words, so you don't have to address everything all at once. But yes, so Board of Appeals member David Thompson makes what I think is a reasonable request. Better for me not to address it because I'm not the best one. So we'll start with Mr. Sturm. If you could address, please, sir, your filed motion to recuse, and that's what I'm calling it, or your request to recuse Ms. Miley.
Yeah, I don't want to get into specifics. I do want to keep things focused on the hearing today, but in the past, Susan Miley and I have had correspondence where she stated explicitly, I have no right to chair the Indigenous Caucus, and made very personal comments about my complexion, about my personality, about who I am. So in the context of these hearings, I don't believe that it's appropriate, considering she's one of the named people. And when we dissolved, one of the named people for discrimination that we faced was Susan Miley. And for her to be judging this just wouldn't be appropriate.
I saw Mr. Sturm took his microphone back to mute, so I'm going to assume that means he's done. Thank you for the brevity. If nothing else, we will move through and we will return back for you to be able to speak to additional matters, sir. If you would like, Board Member Miley, you may address at this point what you've heard and if you have anything to say in response.
Mr. Sturm, his view of events is very different from mine. I just, I don't know him at all. He was attacking some young Dems and I stood up for them and he took great umbrage with it and apparently still does, and was very disrespectful towards myself and other members. I don't feel like I have zero personal issues with him. I think, if this has merit, I will rule accordingly. I don't know him enough to even, I don't think about him. It was never personal for me. I was just defending other people. And unfortunately he takes things very differently than I would, but at the same time, like I said, I have no feelings towards him one way or the other. So I was just glad whenever he stopped emailing me incessantly, but at the same time, like I said, I don't know him enough. This will be completely impersonal for me. I just don't have a feeling towards him one way or the other to really to have any vendetta or anything like that. So I actually I think his his concerns are misguided. So that's it.
So the ruling from the chair would be that a motion to recuse Ms. Miley would be out of order by the board. That doesn't mean it's out of order to bring the matter for consideration, Mr. Sturm. I'm not saying that, simply procedurally and technically. It does sound to me like, and Ms. Miley, I would ask you to confirm because I don't want to misspeak, but it sounds to me like you are declining the request to step aside that has been made. Is that fair?
Fair. Yes, correct.
Thank you. I do believe the motion is out of order for the board and that it is Ms. Miley's decision, as it would be the decision of any individual member. And having ruled the motion out of order, I think it's best to proceed on the motion to dismiss, which does begin at least to get into some of the substance and some factual things. Any objection to proceeding to the motion to dismiss?
I have one slight thing to state for the record is that Susan Miley is on record as saying, I am not fit to lead this caucus and has made very personal attacks. That is an absolute mischaracterization of our conversation. I have it. I can provide as evidence in the future if necessary.
Mr. Sturm, your comments were recorded. And I'm guessing just by the, I'm watching your all's mutes as well. So sometimes that tells me when you're done. If I've cut anyone off, or if I've seems like I'm being rude or railroading over, I'm not. So please, again, wave or speak up. In person is easier with these types of things a little bit. Okay, with that said, I would turn to, so there's a motion filed last night to dismiss. So I would like to know who wants to speak, intends to speak on that. I saw a hand, chair of the Democratic Party, not chair today of the meeting, and today of the meeting, speaking as a party, Mr. Pushkin. Could you please address first? And I would just like to address or say it would be my normal course to go. The person bringing the motion can address the motion, and then Mr. Sturm can respond, and then you could have a brief rebuttal to address anything new that comes up. Mr. Pushkin, if we could address it that way. And then we would proceed as well to give the Board of Appeals opportunity to ask questions if they have it. Thank you. Go ahead.
Thank you, Madam Chair. I'll try to be brief. But first, I hope everybody received and was able to read the motion that was sent out last night, the motion to dismiss with prejudice. If everybody is in receipt of that, I won't read it. I will just briefly summarize and that I move that this board dismiss the grievance filed May 18th, 2023 and brought by the grievant with prejudice for the reasons set forth in the motion to dismiss, which the State Democratic Executive Committee filed and which is before you. So I'll briefly summarize. On May 18th, 2023, the grievant falsely claiming that he is the chair of the Indigenous Caucus of the West Virginia Democratic Party filed a grievance with this board against the West Virginia State Democratic Executive Committee. The grievance is captioned, and I quote, in the matter of the grievance of the Indigenous Caucus. Note that the grievance does not name me. It does not name Executive Director Frankenberry, nor Selena Vickers, who is one of the co-chairs of the Affirmative Action Caucus, does not name us as party respondents or defendants. The grievance merely states that they are targets, but does not specifically name any of us as respondents or defendants. The grievance only names the State Democratic Executive Committee as a defendant or respondent. However, prior to September 13th, 2022, there was an Indigenous caucus recognized by the State Democratic Executive Committee, and the grievant was co-chair of that caucus. However, on September 12th, 2022, the grievant sent an email to the West Virginia Democratic Party and others stating that he had resigned as chair of the Indigenous caucus. And in addition, the board of the Indigenous caucus had adopted a motion stating, and I quote, resolved the Indigenous caucus board members resign effectively September 13th, 2022. They resigned effective immediately. His email also stated that the Indigenous Caucus was, and I quote, dissolved on September 13th, 2022. Thus, by its voluntary actions, the board of the caucus, including the grievant, resigned and dissolved the Indigenous Caucus. The grievant asserts that since the State Democratic Executive Committee took no formal action regarding the dissolution of the Indigenous Caucus and the resignation of all of its board members, the caucus continues to exist. But under the laws of West Virginia, resignation of board members and dissolution of an organization by its board are self-executing. No action is required by the State Democratic Executive Committee. And by my letter to the grievant dated April 17th of this year, which is Exhibit E, which is in the motion, I requested that he, and I quote, cease and desist from representing yourself as affiliated with the West Virginia Democratic Party or from using the logo that you have provided. Contrary to your belief, as a matter of law, a resignation is a unilateral act that terminated your activities with the Indigenous Caucus and with the State Democratic Executive Committee. And the State Democratic Executive Committee did not have to accept it. Your conduct terminated your right to further act on behalf of the Indigenous Caucus or the West Virginia Democratic Party. You are to cease and desist from any and all activities relating to the Indigenous Caucus and or the West Virginia Democratic Party and from holding yourself out as affiliated with either. That was from the cease and desist letter that was sent out on April 17th of this year. The grievant has misused the motion to reconsider that he has brought up in his grievance. Any motion to reconsider must have been made prior to carrying out the motion, actually acting on it. Not only was there no caucus to bring forth the motion to reconsider, but excuse me, in Robert's Rules of Order, the 12th edition provides that the motion to reconsider cannot be applied to an affirmative vote whose provisions have been partly carried out or to any vote that has caused something to be done. That's impossible to undo. Cannot undo the resignation. So a recognized Indigenous Caucus does not exist currently, and the grievant is not chair of the Indigenous Caucus recognized by the State Democratic Executive Committee. Therefore, neither have standing to bring this grievance. And I'm going to bring up our state bylaws and West Virginia Democratic Party bylaws, Article 8, Section 2. It indicates the Board of Appeals shall hear and determine controversies appealed by clubs, organizations, committees, or conventions posing to act as a segment of the Democratic Party. Nowhere in the bylaws does it say individuals or former members may do so. Therefore, this grievance must be dismissed with prejudice. And I reserve the right to rebut. Madam Chair, you're muted.
Thank you. I appreciate that. I was saying, I knew you were done from the mute button. Thank you, sir. And I note the right to rebut. And so at this point, let me move to Mr. Sturm and your response, Mr. Sturm, to the motion to dismiss and the presentation that you've heard. Please.
Thank you very much. And I want to be clear, our case revolves around the party's failure to respect and uphold the democratic rights of the Indigenous Caucus, a recognized group within the party structure. Our grievance arises from a series of decisions and actions, more accurately, inactions, that have disregarded the voices of Indigenous West Virginians within the party. The central issue is the party's failure to prioritize scheduling new elections for the Indigenous Caucus, despite a unanimous decision from the caucus members calling for such elections. The party neglected to act. This not only marginalizes the Indigenous community, but also violates our rights to representation and participation. Following our unanimous resolution to disband due to party's inaction and alleged racism, the party neither acknowledged our resolution nor updated its documentation to reflect a lapse in recognizing an Indigenous caucus. This lack of acknowledgement and response from the party suggests not only that our resolution was ineffective, but it suggests that it was ignored. In this context, I assert that we did have the right to reconsider our motion to disband. The party had not taken irreversible action, and our decision to disband had not been officially acknowledged or acted upon, and our ability to disband a subcommittee of the Democratic Executive Committee is questionable at best and not well defined in our bylaws or in Robert's rules. Now, instead of, and also considering if you take my resignation as being in effect immediately, as the last presiding officer and Chair Pushkin failing to fill that vacancy in an appropriate manner, in a timely manner at the next meetings, I had the right to call a meeting as the last presiding officer according to Robert's rules. Now, instead of addressing these concerns, the party has asserted that it's still meeting the needs of indigenous constituents without our representation. This statement in their motion to dismiss is not just dismissive, it's disingenuous. The party's inaction in forming a new caucus, despite our calls for one, invalidates our agency. It sends a clear message that the party is more willing to ignore us than to engage with us and to address our concerns. This is yet another instance where the party's action or lack thereof have reinforced the systemic marginalization and silencing we seek to challenge. The pattern of dismissing the needs and voices of marginalized communities extends beyond the Indigenous caucus. It reflects a broader issue within the party, impacting other marginalized communities, such as the Black caucus and the LGBTQ+ community, also individuals living with mental health conditions. These communities have all experienced similar patterns of marginalization and silencing. Moreover, the motion to dismiss our grievance seems more focused on personal attacks and diverting attention than addressing the core issues at hand. This reflects a troubling pattern within the party where individuals, including myself, who raise uncomfortable truths, are targeted with personal smears instead of engaging in substantive policy discussion. The allegations against me are not just irrelevant to the proceedings, but they also signal a worrying tendency within the party to silence dissent and maintain the status quo at all costs. This grievance is not about personal disputes or power struggles. It is about an entire constituency within the party whose voice deserves to be heard and respected. Today, we are here to shed light on these issues and to push for necessary changes within the party. We are not seeking personal gain or power. Our aim is to ensure that Indigenous voices are heard, respected, and given equal opportunity to contribute. It's also worth mentioning that in the past few weeks, I attended a DNC Natives strategy session where we discussed the 2024 elections and strategies moving forward. I have never stopped working for the Indigenous people of West Virginia, and I don't intend to. We need to rectify this, whether it's creating a new Indigenous caucus, it doesn't matter. We just need to move forward and make sure that Indigenous voices are heard. And that is why I filed this grievance. Mike Pushkin said, if I didn't like their ruling, to file a grievance, and that's why we're here. And the fact that you all heard it, whether I have standing or not, whether you dismiss it or not, I've had the ability to save my peace and to tell everybody about what's happening. And I thank you for the opportunity.
Mr. Sturm, my lawyer heart would call that day in court, in terms of your ending, in terms of having your say. But with that said, I would be remiss to make sure before we move forward, Mr. Pushkin, do you have any brief rebuttal?
Yeah, first of all, there was an action taken by the West Virginia State Democratic Executive Committee in response to the resignation of the board of the Indigenous Caucus and the chair on May 13th, which was up before this grievance was filed. That in the drafting of our affirmative action plan, in its eventual adoption, that provided for a future Native American caucus. The executive committee did not ignore the dissolution. The executive committee recognized it and did take action to provide for representation, and that's reflected in our bylaws. But I will just also add, and I take any sort of, I've said we as a party also take any sort of accusation of ignoring the rights of marginalized communities very seriously. It has been my experience of many on the executive committee, that this position by the grievant has at times been misused and weaponized as a platform to air grievances, also unduly harass members of the affirmative action committees, and the executive committee. And it does a real disservice to marginalized communities that have been victims of bigotry, have been victims of discrimination, and have been marginalized. It helps nobody. And I look forward to continuing our work here and helping get better people in positions of power in state government here in West Virginia that are able to truly help marginalized communities and everybody else in the state. So I look forward to continuing the work of the West Virginia Democratic Party, doing what we are supposed to do here. However, nothing has changed the fact that Grievance has no standing, and therefore and we still ask for a motion for the board to dismiss the grievance with prejudice.
So with that pending motion, I think it's appropriate for me as chair to entertain first discussion before we would move to a motion regarding the disposition of the motion. In other words, just to rule. So because deliberations are public and we're on Zoom, I'll just go down through each board member. And but again, obviously the board members can deliberate as long as they want, as much as they want. So I'm just trying to keep it orderly, and I'll go one by one to make sure so we can each speak or hear from Mr. Thompson.
Yes. Read the motion to dismiss this morning, and of course, taken into consideration Mr. Pushkin's argument. While I find the motion to be compelling, the lawyer in me says if there is any chance of merit at all to an argument to dismiss a complaint or in this case a grievance. So I'm extrapolating from that knowledge of civil practice. It should be given an airing, so to speak. So that's my feeling on the issue.
Thank you for that comment. And Ms. Miley, any comment, deliberations, your thoughts?
If we dismiss this, it just ends here. But if we don't, do we just listen to the grievances that he has filed and then rule on those? Is that how that works?
Yes, in the opinion of the chair, the board should rule first on the motion to dismiss, granted or denied. And then if it is granted, of course, the case would be dismissed. And according to my read of the bylaws, could only be overturned by a 2/3 vote of the executive committee, which is the same thing that would happen if you would proceed to, if you deny the motion to dismiss instead of granting it, and you would proceed, you would take evidence today from the grievant and from any of the parties who wish to speak, and some of which has been touched on, obviously, regarding the facts surrounding the motion to dismiss. So that's the way I see it would move forward. You as a board, if you deny the motion to dismiss, you would proceed to take evidence today regarding the grievance. You would,
We would just be ruling on those specifically if we don't grant the motion to dismiss.
That is correct.
Okay.
That is my belief. Yes, Ms. Elkins.
I agree with David Thompson that we should listen to everything that gets set before us.
I think, so hearing no further comments, seeing no hand waves from the board members, I think it's appropriate to entertain a motion from any of you regarding the disposition, meaning the consideration of the motion to dismiss, whether it be yay or nay. And I'll just remind the board that I only vote if there is a tie. I would
Are you
entertain,
asking for?
I would entertain a motion from any of the board members regarding the disposition of the motion to dismiss, whatever your inclinations. Including the call for question, or if you have any further questions or anything you want to discuss, this is the time. This is when we have to do it publicly and all together.
Are you asking for a voice vote?
Yes, I think that's what's appropriate. And then,
Nay.
I'm sorry. So I'm not asking, I'm asking for a motion. So I see it as a motion to dispose of the motion. I know it's a motion for the board to dispose of and vote on the motion. Maybe that's too.
I so move.
Is there a second?
I'll second.
It's fine. Go ahead, Kelly.
Call the vote. Moving forward with the disposition of the motion to dismiss. Ms. Miley?
Am I voting now?
No, just to move forward to vote. I guess this is the motion to vote. Perhaps I'm being too technical. Let me just call the vote on the motion to dismiss, which Mr. Thompson has moved that we consider, and Ms. Elkins has second. That's frankly a majority of the board, 2/3. Let's call the vote on the motion to dismiss. Will the grievance move forward today with evidence or be dismissed? So it's a ruling on the motion to dismiss by the three of you. Ms. Miley?
I want to move forward with, I don't know how I'm supposed to say it. I want to move forward and listen to the grievances.
I would interpret that as a denial of the motion to dismiss, which would allow us to move forward today.
Yeah.
And then you will be asked to rule again after you hear the grievances and the responses on those. Mr. Thompson, please.
Nay.
And that nay on the motion to dismiss, meaning the grievance stands at this procedural stage. And Ms. Elkins, please.
Nay.
Meaning that the grievance moves forward today for the taking of evidence and consideration and of the grievances. So with that, Mr. Sturm, you go first in this matter because they are, when I say they, the matter is being considered. This is one grievance filed by you. So the floor is yours, sir.
Thank you very much. So just to lay some groundwork for this. So according to the DNC Charter, Article 8, Section 1, it stipulates the Democratic Party shall be open to all who desire to support the party and be known as Democrats. I allege that Chair Pushkin and Executive Director Frankenberry actions have hindered the participation of the Indigenous Caucus by means of the unilateral, what I consider to be unilateral decision-making based upon my interpretation and others' interpretations of Robert's rules. According to Article 8 of the DNC Charter, Section 2, it explicitly prohibits discrimination in the conduct of Democratic Party affairs based on various factors, including race, ethnicity, and gender. The exclusion and marginalization of the Indigenous Caucus members violates this non-discrimination principle. Their decisions were made without democratic consultation, and they have perpetuated a system that disregards the rights and contributions of minority groups within the party. It's important to keep in mind here that Chair Pushkin claims that the executive committee took action against the Indigenous Caucus, but I would argue that this affirmative action plan doesn't explicitly make it clear that there was a lapse in coverage of the Indigenous Caucus, and it's kind of hiding behind procedural rules, which has been a problem that we've talked about before. We had a grievance in 2021 that dealt with that same issue. Number 3, we allege that according to Section 3 of Article 8, the encouraging participation by all Democrats with particular concern for minority groups, Chair Pushkin and Director Frankenberry's unilateral decision-making has undermined that principle of full participation. The updated WVDP bylaws incorporate the 6 elements of an open party.
Objection. I would say if we're going to discuss a staff member look, I was elected to be chair of the party. We can discuss me in a public setting. If we're going to discuss staff, and we need to move to executive session.
Wait a second. Now, which staff? Because Director Frankenberry is named as a grievant. If we're going to go into executive session, that
He's staff.
negates the
He's
transcript.
not elected.
Are
He's
you
not
gonna-
elected. He's
Wait a second. Can we
staff
keep
of
some
the,
order here? There's no. Why does Mike
Mr.
Pushkin get the authority to speak over me? That doesn't.
Mr.
When we're
Sturm,
talking about discrimination
Mr. Sturm.
and the agency of us,
Mr.
being
Sturm, could you
interrupted by
please-
Chair Pushkin is
Mr.
inappropriate.
Sturm, Mr. Sturm, he can state an objection, and it actually, I think, is an important consideration by the board. That's all he's doing. I promise you, we're going to return to you to be able to speak and address any concerns. But Mr. Pushkin has raised what I consider to be an important concern, and I just want the board to address it before we move on, which is what we're
I
trying
would like to make this
today.
clear. I'm live streaming this on my end. So if we go into
Mr.
executive session, this is going to throw everything into chaos. It's just, this doesn't seem appropriate. Where
Well,
in the
thank-
bylaws does it
Mr.
call
thank
for
you for
executive
disclosing-
session with the Board of Appeals?
Mr. Sturm, thank you for disclosing that you are live streaming it on your end. I do appreciate that disclosure. Sorry, something on sorry, messed up my screen by a notification apparently I didn't turn off. I appreciate you disclosing, Mr. Sturm, you're live streaming it on your end. I think that is also something the board can consider. But what has been raised does have to be considered by the board and ruled on. I believe it's substantive and not something that should be ruled on by the chair in terms of whether or not to move into executive session. I can weigh in if someone disagrees. I believe it, but I believe given what's been raised, that whether or not to move into executive session is to be
Well, I
decided.
have a point of order then. I have a point of order. What is the procedure for determining executive session? If Ryan Frankenberry was named, then this thing should never have been advertised as being public because it was always going to include talking about Ryan Frankenberry. So I'm confused about the procedural rules here. It just seems like more hiding behind the rules to keep the truth from coming out.
Mr. Sturm, thank you. Mr. Pushkin, go ahead. You can respond.
Yeah, it's clear when discussing matters of personnel, and our executive director is staff of the party. When discussing personnel, we would go into executive session. If you want to
We're talking about
discuss-
discrimination.
You want to
against the
discuss someone
Indigenous
who's
caucus,
elected,
though.
you want to discuss.
But we're talking about the
grievance
actions of
against
the
me,
party.
It can be public.
Mr. Sturm,
But-
could you
so-
please let,
wait a second. So
no, Mr.
wait
Sturm,
a second. Can I have a
you have
question? I
to
have a
let him
question.
finish. Could someone mute him? I'm not doing this.
I'll mute myself. It's fine.
Okay, Mr. Sturm, I promise you I'll let you speak. I will not speak over you. If I do, I'll be quiet, but we have to let Mr. Pushkin speak and then you'll have an opportunity to respond. But we heard you on that. He is citing the reason for his motion, and then I'm going to go through and see the thoughts of each board member. It's a little more frustrating over Zoom. I promise you'll get to address it. Mr. Pushkin, please go ahead.
Can I address it before the board discusses?
Mr. Sturm, you already did address it, and I will circle back to you. How's that? If I could just hear what Mr.
Well, I didn't get a chance to address that directly, so that's not true.
Mike, go ahead, please. Mr. Pushkin.
I made the point.
Okay.
In matters of personnel, I would request, it's in the bylaws, in matters of personnel, we would go into executive session.
Mr. Sturm, please go ahead and have the final word.
I'm not trying to get Ryan Frankenberry's job. This isn't about personnel. This is about actions taken by the party. If staff is allowed to discriminate without transparency and public accountability, then all of this is for naught.
Okay, Board Member Miley, your thoughts, please.
Is there a way to address the grievances for the public members of the executive committee first, and then kind of deal with the personnel actions? Is that a possibility? And I just don't know. I'm just asking that. I recognize both sides, I think, on this argument, and I do think that we have to guard privacy rights for staff members, but then at the same time, on the discrimination side, if you have that feeling, then it needs to be addressed. But I almost think that needs to be on the personnel side of actions of your staff are being, if you need to address that internally with staff, I do think that is different than when you're dealing with public entities like the state Democratic Party. I would not let my staff of my business have their stuff aired publicly. I think that that is a privacy thing. And I do think that you have to look at that as business, and then you do have the elected members of the state party. So I do think that is a valid point that Mr. Pushkin has brought up, because that is an internal, when you deal with staff that are, maybe doing something, and I'm not saying, anybody is, I'm just saying that if you are dealing with staff that are doing something inappropriate, you really should be dealing with that on the business side.
Thank you, Ms. Miley. Mr. Pushkin, I see your hand.
Yeah, thank you, Madam Chair. As the, elected chair of the West Virginia Democratic Party, I would take full responsibility for actions of the staff. If we are to discuss, if we are to stay in what I'm saying is I take full responsibility for, and would if any allegations would be brought against me as the chair, we can stay in the public forum, but we're not going to discuss staff in a public forum.
Board Member Thompson, do you have anything to say, sir? I don't mean to question everybody. Again, I'm trying to make sure everybody has a chance to speak. Oh, and you're muted.
I would sustain the objection, and the reason being is, once again, I just look at my legal training. I would compare this to a respondeat superior kind of argument, that ultimately Mr. Pushkin is responsible for staff conduct, and I would prefer that Mr. Sturm can still make his argument, except maybe use more generic terms, staff member A or staff member B or something along those lines. That's all.
I would agree to that, by the way. I have no problem with that moving forward.
I was going to circle back to you. Thank you, Mr. Sturm. Because I do hear an agreement in the works with regard to how this gets addressed. But before I do that, if I could just make sure, Ms. Elkins, do you have anything to add?
I do not. Thank you.
Thank you. So at least what I'm hearing, not trying to, please someone tell me if I'm wrong, I'm sure you will, but I'm hearing that we can agree there won't be any mention of staff members' names. Mr. Pushkin is responsible for the members, the staff members as chair of the Democratic Party. And we do want to protect privacy rights of employees. And I think an employer has a duty. I think we all know that. So Mr. Sturm, you are in agreement with proceeding that way, that no names will be used with regard to people that are known employees?
If Mr. Pushkin takes responsibility, I accept that.
Thank you, sir. Okay, very good. I'm glad we worked that through. Easier or harder on Zoom than in person, but okay. So let's move forward. Mr. Sturm, that was at a point in your presentation where there was an objection and we got sidetracked with that discussion. I'll return to you to continue your presentation and discussion.
Okay, so now we've moved on. So basically the crux of this with my actual grievances against the party, like I said before, was in a conversation with Chair Pushkin. He suggested that if I had a problem with the party not recognizing the Indigenous Caucus, to take it up in a grievance. And so that's why I proceeded. I can understand if people have some questions about the violations. The real violations come after, it depends on how you read this. So if it all comes down to whether or not the Indigenous Caucus has continued to exist, ceased to exist, why there aren't calls for a new Indigenous Caucus. Like I said, our grievance here relies on us. If our motion to reconsider was valid and our calls for a new election were ignored, then the bylaws were not followed, because we scheduled that and we noticed it the way that it's supposed to be noticed according to the bylaws, and the party didn't put it on the calendar or go through with it. So we canceled those elections. We're not trying to go above and beyond. We're trying to follow the rules. We're trying to do things the right way. And at this point, we would be happy with the reformation of the caucus and new elections. We don't want to see our hard work be erased. I think that it's important to keep the transition from the old caucus to whatever new caucus they want to come up with. Again, this is all about getting Indigenous caucus representation. So if the ruling is that we didn't have the right to reconsider, then my question would be, when are we going to move forward with forming this new caucus? And will the new caucus be set back, or will they be able to recognize the work of the old caucus moving forward? Because again, we have 10 active members who unanimously voted to reconsider this motion, who want to have a voice again, who want to be active again, and who have done hours and hours of work for this party. And I believe that they deserve to have that work recognized. This isn't about me. This is about the Indigenous constituents who I represent, and that's who I'm speaking for today. So my evidence is that we unanimously voted this on April 17th. We were denied access to vote in the AAC elections the following month. And our elections weren't scheduled according to the bylaws or announced through the party website the way that they should have been. So those are the grievances. And again, this is just about Indigenous representation. There's no real vendetta here. So that's all I have to say. I'll let the proceedings move on because we've been here quite a while already.
Mr. Sturm, thank you. I see your mute button back at this point, and I believe that proper protocol would be to give you the last word in this presentation. And I will circle back to you on that. It doesn't mean you'll have to speak, but if you want to, you'll have that opportunity. Mr. Pushkin, at this point, I'll turn to you, I think, unless there's someone else who wants to speak. Okay, very good.
May I ask the grievant to yield?
Yeah.
Okay. Do you mention that there are 10 members, 10 former members? I watched the YouTube or the Zoom meeting of the meeting on September 13th of last year when the caucus resigned and he resigned. There were 2 members on that. I believe there was a mention of 2 more. So who are the 10 members?
The 10 members, I have a list here. If you'll give me 1 second, I can get you a list. See, now this is concerning that the chair of the party, it doesn't even know who the members of the Indigenous caucus are. It shows that disconnect that I've been talking about. But I will answer your question, Chair Pushkin. 1 second. I'm in the wrong. Okay, hold on. Here we go. Okay. And again, 10, I might not be exactly 10. So we have myself, Mary Rowan, Sandra Lynch, Jason Hayes, Charlene Myers, Alice Masters, Whitney Wells. And we have Gregory Wingo, Mac Halterman. And then we have several ally members, including Chris Loken, Gary James, Marlene Midget, Marianne Clater, Kim Felix, Camilla Murray. These are just going through my emails. I'd have to get the roster, but yeah, we have plenty of members. We've been very active. And,
Thank you. Would you
I'm not
continue
sure
to
where you're
yield?
getting your numbers.
Would you continue to yield? I don't have any numbers. I was asking you because you presented the numbers. Would you continue to yield, sir?
Yeah.
Okay. So according to your bylaws that were adopted by the Indigenous Caucus, wouldn't one need to be a dues paying member to a recognized tribe in order to be a member of the caucus?
No, you have to be so we have a system set up because Sandra, I am a recognized member, first of all, before you go there. Secondly, I'm a member of the Navajo tribe. Secondly, Sandra Lynch is 50% Native American, but does not have tribal affiliation because she was adopted. We made special leeway for people who wanted to self-certify with the DNA test. But to be a voting member, you have to be affiliated with a tribe, which all of the voting members are. So,
and how many voting members are there? How many voting members of the caucus do you have?
Okay, hold on. Again, let me count. Myself, Rhonda Sturm, Mary Rowan, Sandra Lynch, Charlene Myers, Jason Hayes, Whitney Wells, Alice Masters, Gregory Wingo, Mac Halterman, 10.
So they are members of a recognized tribe?
We're still waiting on Mac Halterman. He hasn't responded to anything, but everyone else is, yes. Or married to into a tribe, yes.
Well, the reason I'm asking, are there any recognized tribes in the state of West Virginia?
Okay, now we're getting into the area that we've had trouble with. That was one of the first issues that we had with somebody stating that there are no indigenous constituencies in West Virginia. We have tribal affiliations and we live in West Virginia. I am a Navajo living in West Virginia. My tribal affiliation is in Arizona, yes, but I reside in, and have lived in West Virginia my entire life. The people I represent, most of them have lived in West Virginia their entire life. Transplants who come to West Virginia need representation within the party. I'm not sure where this questioning is going, but I'm offended.
Well, no, no offense intended. What I'm getting at is it an inclusive caucus, or if there are rules set up that if there are no recognized tribes in West Virginia, how many dues paying members of recognized tribes are there in West Virginia that could be eligible to vote in the caucus that you've started?
Well, we already have 10 voting members, which is more than some caucuses have, and we're continuing to do outreach all the time if we could get the work done. We've been unable to meet because of procedural rules set forth by you, Mr. Pushkin.
What constitutes a quorum in your caucus?
We have no rules for quorum.
Okay, so you say you have 10 members, but if 2 people show up, that's a quorum?
According to our bylaws, yes.
All right, well, thank you for yielding.
Oh, and I would also like to point out, if I'm sorry, it is worth noting that we were denied access to vote builder accounts, and we were denied the ability to create a PAC, which has been apparently granted to the Women's Caucus. These are issues that speak to the heart of the systemic nature of the disenfranchisement and the discrimination that we're facing. We are treated unequally, even by our own rules, by our party leaders. So now I will yield the rest of my time.
Thank you, Mr. Sturm. Mr. Pushkin, did you have more?
I have no more questions. I would just, briefly state that, I said the Democratic Party in West Virginia, we are trying to see how to put this. We, intend to be all inclusive. We are all inclusive. We are pride ourselves on our transparency, and and I stated this before. What's troubling to me is then when one uses a position in an area that's supposed to be there to help bring people in, that's supposed to add to inclusion and benefit marginalized communities, but uses that position instead as a platform to lash out, as a platform to harass members of the executive committee, to harass members of other affirmative action caucuses. I could bring up I'm brought to mind the relentless harassment of Ms. Clifford, to the point where I believe she stepped down from a position, and other people who stepped down from positions because they were just worn down by the constant harassment. That does nothing to actually bring people into the party. That does nothing to
I do have an objection here. This has
to
absolutely nothing to do with the indigenous caucus. This is personal smears, and it has no place in this hearing. I object to this wholeheartedly. These are lies. Emily Clifford did not step down from any position. She went on to chair the AAC. Emily Clifford engaged in a harassment campaign with Shane Assad-Zandi, chair of the Mon County Dems at the time, against me on social media. These are mischaracterizations, and this is no place in this hearing.
Your objection is overruled. I appreciate your response, which I will give you an opportunity to respond and have the final word. But Mr. Pushkin has a chance an opportunity to make his case and state matters as he sees them.
Yeah. But what I'm saying is I am willing to work with anybody who wants to work in good faith to help us build a party that we can be proud of and thus elect better people to office and to elect Democrats and to defeat Republicans. I'm willing to work with anybody who is acting in good faith to do so. It has been clear since I first encounter with the grievance, he has never been acting in good faith. This has always been about a platform to spew anger and to harass people, to harass good people who are working in good faith, and to run people out of the party. You know, I'm here to do the work to help elect Democrats and help build a party we can be proud of. And I look forward to continuing that work.
Mr. Pushkin, thank you. Mr. Sturm, as promised, I will give you the final word to wrap up what I see as the evidentiary presentations and statements regarding the written grievance.
Yeah, I know this is just, I believe that I have standing. I don't want to get into these personal matters. It has no, I would, responding to and exposing racism and discrimination and calling out the people who are responsible is not harassment, is what I will say to that. And just that this hearing is about the entire Indigenous constituency. They voted me to be their chair. They trust me to represent them. All of our decisions, most of them have been unanimous. I don't speak for myself. I have not abused my position. The Indigenous people are behind me with the decisions and the documents that we put forward. So to classify it as all being personal just does a disservice and removes agency from a lot of Indigenous people who are actively participating in our caucus and trying to get the word out about our lived experience within this party and the abusive nature of Mr. Pushkin's statements and the personal nature and the smears. I just find really, really unprofessional and just indicative of the totality. It shows cases exactly what we've been going through, from the Black caucus members to the Indigenous caucus members to trans women in the executive committee. It's just been one thing after the other, and we have to do something to ensure inclusivity and stand up for the democratic principles that we say we stand for. Thank you.
Very good. Thank you, sir. I do believe everyone, you know what, do I see a hand up from Ms. Vickers?
Yes. Would it be okay if I spoke to some of the points made in the grievance, specifically related as the co-chair of the Affirmative Action Committee?
I would rule would be okay, but I will let Mr. Sturm know that I will give him another opportunity to speak to anything new that you may raise, which I assume that's why you want to speak, something new or maybe that hasn't been addressed. So I do think it would be appropriate for you to speak with him having the opportunity to respond.
Of course, thank you. I wanted to specifically speak to one of my concerns about the grievance is that there are some vague statements about violations of Democratic Party rules, but no specifics. There's no evidence. And he specifically started out by talking about Article 8 of the Charter. And anybody on here, I think most people on here know that I did an enormous amount of work over the last few years focusing on full participation for West Virginia Democrats, especially those of historically underrepresented groups. And so I feel like because of that work and the very, very deep dive that I've taken into the DNC, or the National Party Charter and the DNC bylaws, and because of my role related to the Affirmative Action Committee, that I could speak to those things. I think that the grievance fundamentally misunderstands the term full participation and what that means in terms of the charter and bylaws. In the motion to dismiss, Chair Pushkin, and it starts on paragraph 37, if you want to look, lists all of the things that the West Virginia Democratic Executive Committee has done over the last few years to provide for full participation for Native Americans in West Virginia. And I just want to go down it because I also want to be very, very clear that this was not done prior in the past. Like that there are years and years and decades that have went by without not only Native Americans, but other historically underrepresented groups having full representation or full participation in the West Virginia Democratic Party. And that is drastically different now. In 2021, the West Virginia Democratic Party, I think it was in March of 2021, they adopted bylaws which provided for the creation of a Native American Diversity Caucus. The West Virginia Affirmative Action Committee did outreach to Native Americans. The West Virginia Affirmative Action Committee called for and facilitated an initial meeting of the Native American Caucus in which 2 co-chairs were elected, of which the Grievance was one. His sister was the other. The state party hosted every official Native American caucus meeting that was duly called by the co-chairs of the Indigenous Caucus and was provided to the state party through the events calendar feature on their website. The state party included the Indigenous Caucus co-chairs in all the official affirmative action correspondence, including invitations to AAC meetings. They elected a Native American as a member of the state party. That happened in June of last year. They adopted, State Executive Committee adopted an affirmative action and outreach plan that provides for representation of Native Americans on the State Executive Committee. That is what the National Charter Article 8, Section 3 is about having a plan, an outreach plan that provides for representation for historically underrepresented groups, basically proportional to how they participate in the Democratic electorate. That's sort of a big deal. And that we have that. We adopted that plan, the State Executive Committee did. They adopted a delegate selection plan, another really, really big deal. And this is for the 2024 convention, which provides for representation, a representative goal of Native Americans. So to make sure that we have Native American representation, or at least have the goal of that for the 2024 National Convention. And then following, and this is one of the things that the Grievance said, is that it was ignored, that the resignation and the dissolution was ignored. It wasn't ignored. It was so much paid attention to that on May the 13th, the State Executive Committee adopted bylaws that recognized that they had dissolved and made accommodation so that a future Native American caucus could be formed and be a part of the Affirmative Action Committee. So it very much was listened to and recognized. And on top of that, an action was taken to ensure future representation in terms of a caucus. All of that stuff that I just went over is absolutely 100%. And you're welcome to go to any, talk to the Rules and Bylaws Committee chair of the DNC. This is exactly what Article 8, Section 3 is basically Article 8 is about. The other piece of the DNC bylaws that are really important is the DNC bylaws, Article 2, Section 11. It's all about full participation, about making sure that people know about when meetings are and things like that. The problem with the accusation of the Grievance that his wanting to put a new caucus together or to reform the caucus and not having those those notices go out is because he at that time had resigned and was not a part of the Democratic Party. He was, it would be like, you know, your neighbor who is a Democrat, but is not affiliated in any way, not part of the executive committee, not part of anything, calling together an official meeting of, you know, a Democratic group and saying we are a formal Democratic group without having any standing whatsoever within the Democratic Party. Like, you can't do that. Now you can get together and say, hey, I'm a Democrat and I want to get a bunch of Democrats together and we want to apply to be an official group or something like that. That's one thing, and you get permission. But what happened was the entire caucus was dissolved. They did it on live. There's YouTube videos of it.
Objection. Can you state why the caucus dissolved and were you named?
I believe Mr. Sturm is asking Ms. Vickers to yield to a question.
I'm not going to yield right now, but I'll be glad to come back to you.
Mr. Sturm will turn to you as well to speak. Go ahead, Ms. Vickers.
So it dissolved, and there was an email. I received it. A bunch of people received this email. I think the whole state executive committee that the Grievance had resigned from his role, and that the caucus had dissolved, and that was the end of his involvement as a co-chair and his end and the end of that caucus at that time. So that was the standing issue, and I completely agree with the chair that they don't have standing to bring this forth. But that is why a regular person cannot say, I am in charge of something within the Democratic Party and expect for our staff to put that on and make that an official meeting. I think that's a reasonable thing, and you can imagine what could potentially happen if that was not the rule. What potential bad things could possibly happen if anybody could just say, I am in charge of something in the Democratic Party, and pull together meetings and act as a member and a leader of the Democratic Party without standing. So anyway, those are some things that I wanted to bring forth. I just wanted to clarify, and I follow the DNC, the party rules, probably closer than anybody else in West Virginia. I mean, that's sort of my thing, but I can tell you that absolutely West Virginia is very, very clear and very good, in my opinion, in following on full participation, and specifically Article 8 and of the charter and the bylaws, Article 2, Section 11. So anyway, I'm glad to take Mr. Sturm's question now.
I was just stating, could you state why the caucus dissolved and were you mentioned in the dissolution?
I have it in front of, no, I don't have it in front of me. I don't have it in front of me.
Well, I can answer that. Yes, you were to both things. See, we have the situation here where Ms. Vickers has been part of a YouTube series talking about how she can use procedural rules to take over a state party, has been on the record. Mary Ann Claytor has stated on the record and has witnessed it that Harold Ickes from the DNC has advised Ms. Vickers on how to silence minority members of the AAC.
That is not true.
Mary Ann Claytor
that is what you say, and that is not
hold
true.
on, wait a second. May I speak? May I speak? That is what Mary Ann Claytor has
You can
testified.
speak, but I will say that when you lie, yes.
Well, okay. Well, I'm sorry, Ms. Vickers. Can you please wait a second? Because I'm trying to state a fact that Ms. Mary Ann Claytor was at a meeting where she heard Harold Ickes state that explicitly. So either
That's
you're
not
saying
true.
Mary Ann Claytor lied. Okay, so Mary Ann
What
Claytor
you're
is lying
saying is not true.
and when we asked for the video, a lie was spread around that Mary Ann Claytor and I were somebody named Jesse Spain, and we're harassing members. This is
wait 1 second. Here's the thing. Hold on. No, for once.
Well, what do you mean?
No, let me just say this.
I was interrupted.
I don't think it's right that we're saying someone else said things like that. I think that having someone say they're on record without
there is a record of it. They won't release the video. They will not release the video. It exists. Eyewitness
I think
eyewitness
we should
testimony doesn't
stick with
count.
the
I'm
facts.
sorry. Who's they and what video?
I just, no.
Okay,
let
may
me
I-
just-
may I
Can I
answer
please
that?
say this point? I think we should stick with the facts from the people.
It is a
that
fact.
I don't think that you should be speaking for Mary Ann Clater. I think that we need to just stick with the
I'm
grievances
stating
where
a
we're
fact.
at. And this is going a little off the rails, and I want it to come back. And so no more.
Ms. Vickers,
He said,
Ms.
she
Vickers
said,
brought us there.
This is just, you state your point on why
It's-
you felt that you guys needed to
I
dissolve the
am. That's
caucus,
my.
and
This
but
is
you
relevant.
don't, but
This
don't
is
bring in
completely
everybody
relevant.
else. You
But
you
this is
chose,
relevant, Miss
wait a
Miley.
minute, you chose to dissolve it. Just say from multiple
Out
people,
of
multiple
because oh,
sources.
wait a second.
That's fine, but I really
That
think that we're going off the rails whenever you start claiming he said, she said, we said, they said. That's really going off the rails. Let's just try to stick
It's
with, you
relevant.
dissolved it for this reason, but
Which was
no, on the
racism. That
record,
goes back to the
I don't
again. That
know.
goes back
I
to
have
my
to tell you,
point.
I don't think that, I do know Mary Ann Clater. I don't think she probably would like to have her name being thrown out all the time. It's just. I
You're
think
speaking
that
for
we're
Mary
going-
Ann now, huh?
I'm just saying that I prefer that we just try to stay on point. And it's not.
It was relevant.
Okay.
May I finish
right.
my point? It was relevant to
yes,
the
one
point I was
second.
trying to make.
Mr. Sturm, 1 second, please, if you would, and I'll return directly to you, I promise. We can't talk over each other, and we have to have some level of respect, even though the matter is being discussed or there's some conflict involved. So what I will say is, I do think that it is a point of order to suggest that the board and board member Miley doesn't want to hear evidence that's essentially hearsay that's offered to prove
Well,
the truth.
it's not hearsay. It was.
You're Mr. Sturm. You're interrupting the chair. If you'll let me speak and let me
Okay,
finish.
that's fine. But I'm saying you're
Mr.
ruling
Sturm,
unfairly. I disagree.
No, I'm not ruling on anything. I'm simply calling order and asking for us to please
I've
follow.
not had a chance to
Mr.
speak.
Sturm,
Susan Miley, Vickers, and
you
Torres
have
Davis have been
interrupted
speaking over
me
me.
3
I've not
times,
had a
sir.
chance. Okay.
Mr. Sturm, you have had nothing but opportunity. We've been on here and you will have it again, I promise. Please
You
don't
keep
interrupt.
interrupting me. I wasn't able to finish my thought whenever I was speaking because Susan Miley interrupted me, and now I'm being lectured at because I am not following civic procedure. Civic discourse
Mr.
in civic
Sturm,
politics is for the oppressor.
you
And
are
I was
not
not
in
finished with
charge.
my statement. I know I'm not because the white women have decided I'm not, and they will speak over me. So I will yield the rest of my time. I will say nothing else.
Well, so you're muting yourself. That's convenient because I was looking how to do it quickly. Very disrespectful, calling the order. Anyone can
Agreed.
speak, including Mr. Sturm, including board member Miley, including Ms. Vickers. Everybody has the opportunity to be heard, Mr. Sturm, including you, but not just you, and including the chair. Now, with that said, is there anything further, Mr. Sturm, that you have to say regarding anything that's been said? Before
Yes,
we
I was addressing it before
Yes,
I was
sir.
interrupted. That's what I'm trying to say.
Interruptions will be dealt with by the chair, sir.
I
And sometimes
understand.
interruptions are out of order. And sometimes we make objections all the time when we don't like what we heard, but they'll be ruled on and we'll move on. You have also interrupted many times today. So let's try not to interrupt each other and move forward. What do you have additional to say, sir?
I was directly addressing the reason we dissolved, which spoke back to that previous conversation that you're saying I can't speak about. If I'm not allowed to speak about the actions of discrimination that we have faced, it's going to be pretty difficult to come to some sort of understanding. So I will yield my time and just wait for the decision of the board, since my lived experience has no bearing on these hearings with you all.
Just to point out, I have no problem listening to lived experiences. I was pointing out just when you're saying others' lived experiences as statement of fact without them being.
That was part of our
voiced.
grievance in 2021. It was accepted as Mary Ann Clater testified to it. It was accepted. It's part of the Board of Appeals record in the past. That's why I brought it up.
Well, but absolutely speak about your lived experiences. That's why we're here.
Right. And I lived that experience, just so everyone understands.
So I think what Ms. Miley is saying, Mr. Sturm, is, and this is a good opportunity, if you have anything further that you want to add regarding your lived experiences, I think the board members are all ears, is what she's saying. You suggested perhaps there was more to add, or that you were not going to add it, or you felt like you were being silenced. The floor is yours, sir. And if you don't have anything further, that's okay. And I'm judging by the mute that you don't. Just jump in, I guess. I'm not seeing a hand. That said, I think it is.
Mr. Sturm has put in the chat that he has lost audio, and I am uncertain why.
Okay, thank you. So lost audio. So I wonder if he can hear us. Maybe he'll respond in the chat. I see a mute button symbol on his logo on
I'm sorry, my audio cut out. If you could
There you
repeat that, I couldn't hear you. I was struggling to get I'm sorry.
No problem. So we did get a message in the chat that you were struggling with audio. So no problem at all, Mr. Sturm, excuse me. I think there was a concern by Ms. Miley. I'm not sure how much you heard. I'll repeat it all. By Board Member Miley. As to your lived experiences, the board is all ears, and we want to make sure that you didn't have anything further to add, and that you didn't feel like, I mean, the floor is yours. No one is trying to silence your lived experiences.
Okay, this is the only thing this is what I want to bring up. Everything that I've done has been in pursuit of representing the Indigenous people and making sure that we have a standing within the party and that we have a voice within the party. We've been ignored every step of the way. We've been denied access. We weren't able to participate in affirmative action committee subcommittees for drafting the plan or drafting the rules, despite in one of the first meetings we had passing a rule that said that we could join just by volunteering. The chairs of the affirmative action committee denied us the right after that meeting and then changed the rules at the next meeting. There has just been a constant barrage of procedural rules levied against us in a disingenuous, bad faith kind of way, just to limit our participation, because apparently there's an agenda that doesn't involve our caucus and what we're doing. And they view us, I guess, as some sort of obstacles, the way it seems, because anytime that we voice opposition to anything, it's met with extreme hostility. And really it's been a very traumatic experience being on this committee. I'm somebody who can withstand a lot of embarrassment and a lot of hostility. I'm here today. I knew this was going to be brutal, and I'm here for it. I stand by pretty much everything I've done. I know that emotions can get high, but when you're working as a minority in this kind of a situation and you're representing Indigenous people, tensions can get high. And whenever there are discrimination, whenever there is racism that's directed at you, whether it's intentional or not, I'm not saying that everybody has this racist drive. It's just that they've engaged in behavior that has ended up marginalizing Indigenous people. And that's what I want to rectify. I don't want this to come off as a just personal vendetta. There doesn't even need to be action taken against any of the people named. These are the things that I saw that were violations of our rights if our vote to reconsider was legitimate, which again is the crux of all of this. And again, I would say that this argues to the spirit. We can argue the rules and the letter of the law all we want. The spirit of this is that the party did say they want to form a new caucus. So I'm here for that. I want to see that. I want to see new elections, but I would also like to see the work that we did previously be transferred. I want to see that more than anything. I just want to see the work that we did be acknowledged. I really don't even want to be the chair too much of this caucus. It's not about that. It's about making sure that we have that representation and we have the ability to be heard whenever, they're talking about, well, the Indigenous people are still represented. We're still concerned about getting them heard. We're right here. There's 10 of us who are actively trying to participate in the party, and we're being told, wait until we say it's okay. Well, when is that going to be? How long do we have to wait until it's acceptable for us to organize and to start doing the work? That's where I'm at. All of this has been confusing, not fun. And I just hope that moving forward, we can get to the place where we can do that work that's needed to be done to move this party forward and get rid of all of this infighting. Has done nothing. We're in a party right now where the GOP has a supermajority. Fascists, and I'm not being hyperbolic, are taking over this state. If we don't come together and actually start working together and working with each other and utilizing the skills that we have to build this party back into something bigger and better than it's ever been and fight back against this GOP, there's not a state to fight for. There's nothing to fight for, okay? So this infighting is just pointless, and I have no time for it. So that's where I stand. I just want to see what's happening with the Indigenous people of this state and representation within the party. Thank you.
Thank you. Mr. Sturm, I'm judging by your mute button self-imposed there that you are finished. Thank you for that. I think this is an appropriate time, what I would be to call the question, meaning do the board members have any questions that haven't been addressed that would affect your ability to deliberate and or rule? Of anyone who's spoken, frankly. And if you don't, that's okay, but I want to put that out there as an opportunity since we're in this Zoom setting. See no hands. No, I think not. Okay. So with that said, I would entertain a motion that we move to disposition of the grievance by the board, by any of the board members.
So move.
Is there a second?
Second.
So the motion is to move to disclose the evidence, move to disposition of the grievance based on what's been heard here today. Calling the vote, Mr. Thompson. The vote on moving forward with disposition.
Aye.
Ms. Miley,
Aye.
Ms. Elkins.
Aye.
With that said, I think it's appropriate to publicly deliberate should you choose. This is obviously up to each individual member, and deliberations can also be between members. But this is the time for that. If there's anything that you want to say or add on the record as members of the Board of Appeals.
I don't have anything.
You
Thank
know,
you,
for myself, I think that whenever you're dealing with a lot of personalities in any organization, that sometimes the personalities can clash, but it doesn't mean that people are intentionally trying to hurt anyone when that happens. And I think that to me is what's the issue. It's the personality clashes. I know as a Hispanic female being raised in West Virginia, I know that when someone doesn't like me, or they may, it's not always because that I'm Hispanic. There may be a time when it is, but or it's hard to work with me. I know it's not because I'm Hispanic, or when someone makes a rule or a decision about something I don't like, it's not because I'm Hispanic. It's not because my dad's Mexican, you know? So I just think that whenever you have a lot of personalities and a lot of different perceptions on how things can go, it can sometimes feel like you're being targeted. But I don't think that that's always the case. And I did appreciate Selena going through the rules part, because I was unclear on all of the rules. I did read about them, previously whenever we got all this stuff. And I just, that part was confusing to me. I do know that it was voted on recently, the way that the committees were going to go. And I personally just think following the rules at this point. And I do think that sometimes we can make a rash decision by maybe stepping down or I've seen people remove themselves from the party, but then later want to get back involved. And I appreciate when they want to get back involved. I just think that you have to still follow the rules, even though you may not have made decisions the way you thought. You made a decision that didn't turn out the way you thought it should in the past. So and that's me deliberating what's inside my brain openly. And I don't know, but that's just where I'm at with this process.
Ms. Elkins.
I have no comments.
Mr. Thompson.
I think you asked me already, but I didn't have a comment.
But you lit up green, and I thought that meant you wanted that you wanted attention. That was me misreading, and I apologize, sir. Yes. Okay. So I think with that said, and there are no further deliberations to be had on the record, that it is appropriate for the Board of Appeals members to decide, to make their decision as to the disposition of the grievance on the record. I think it's appropriate to call for that disposition in the form of a motion or a vote by one of the board members based on how you see it.
I move that we take a vote.
I second that, but I do need to clear, I do need you to like tell me how that I mean, like how the vote would, what I need to say to clearly explain my vote, but I second his.
So I agree. I think it's appropriate for the chair to call for a motion, and one of the board members can formulate that motion in terms of the disposition that they are moving for. In other words, if someone has a strong feeling it should be, whether it should be granted, whether it should be dismissed, if granted, what relief. And so I would call for that motion if anyone sees fit to make it, whatever direction you're inclined. And then that's how, and then we could proceed to vote on that motion. I think that's the best way to proceed. It's a little mixed up, right? We're having a hearing and we're also trying to follow Robert's rules regarding meetings. So it's a little bit of a mix. But I think that the options are that you grant the grievance, that you deny the grievance, or that you continue for some reason, there's more evidence or information that the board might desire to hear, or additional people, if the board would make that choice. I think that would be up to you all. But I think those are the three options. And if granted, the board would need to certainly craft the remedy.
Very well. Can you hear me?
I will say just, and please, Mr. Sturm, I know you will correct me if I misstate, and please do, sir. But I do believe Mr. Sturm said that he wanted no action against any individuals, but that essentially he wanted to be heard here today for what that's worth. And yes, sir, Mr. Thompson, I can hear you.
All right, I would offer a motion that the board be polled as to sustaining the grievance based on the nomenclature denied or granted, with denied being that the grievance is not sustained, and granted being with that the grievance is sustained, and from there move on depending on the outcome to what relief the board might consider under those circumstances.
Thank you, Mr. Thompson. Is there a second to that motion?
I would second that.
Ms. Elkins, thank you for that second. And so as I understand the motion and the vote is whether the board members will be polled, whether the grievance will be granted or denied or continued, I suppose, which is an option, not that you brought that up, and go from there if further action is needed. Mr. Thompson, do I understand that correctly?
Yes.
Have I read it? Thank you, sir. And with that, I would call the vote. First of all, is there any discussion on the motion? Hearing none, hearing no request for any, I would call the vote on Mr. Thompson's motion, which is that you state whether you would grant or deny the grievance. Mr. Thompson, I'll let you go first since it's your motion.
I would, yes, thank you. I would deny the grievance.
Thank you, sir. Ms. Miley?
Deny.
Ms. Miley is also denied. Thank you, ma'am. Ms. Elkins?
Deny.
Deny. Very good. So with that, I see the point of your motion, Mr. Thompson. There's no reason to consider the remedy if there's a unanimous vote, and there is. All three are on the record of denying the grievance. I think that ends this matter with regard to the grievance. Of course, the bylaws provide for what happens to grievances and what happens from here. And we all know that any decision this board makes is is the final word, unless overturned by 2/3 of the members of the State Executive Committee. I would certainly, I don't want to cut anyone off prematurely, but I think that ends our discussions here today with that vote and that ruling.
Thank you, Teresa. You did a really good job.
Thank you. Thank you. I appreciate it. I apologize for the disconnects to the extent they happen because of Zoom. It's very, very hard. But that said, hearing nothing further from anyone, the grievance for the record has been denied. And that ends the matter for this Board of Appeals and for this meeting. And I thank everyone today for patience in working through all the details that we needed to work through. Thank you all.
Thank you.
Thank you.
And at this point, I think a motion to adjourn is appropriate.
So moved.
I would so move.
Second.
Second.
Smiley moved and Mr. Thompson seconded. I think Ms. Elkins was in there with the third. Not that.
We're all
So
like,
you're all-
yeah.
Thank you, everyone, for your patience and mutual respect here today. I do appreciate it. Thank you.
Thank you.
Thanks.